Hello, members. Welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand for everybody. And today we are diving into the course unit of Introducing Law, and we are going to look at the schools of thoughts or theories of law. And we shall be taken through by a legal genius called Phelistah Akinyi. We are so grateful to have you at Agora Legis.
Thank you. My name is Akinyi Phelistah and I'm so happy to be here. And today we are going to indulge ourselves into schools of thoughts. This is under introducing I don't know, one members, this is the legal platform for you. But whereas still one students, still you can be a fourth year student or second year, but you didn't understand. So Agora Legis is here to give you the best of it. Well, for starters, let's schools of thoughts. What is school of thoughts? What are the schools of thoughts? These are legal theories developed by different scholars. We shall mention the scholars. Some of you talked about these scholars in history. That is history A level. We talked about people like Rousseau. Different people have their different pronunciations, but Rousseau, John Locke, in the French Revolution. Well, the schools of thoughts. We are going to talk about different, there are kind of like there are 6 to 7 of them, and we are going to tackle all of them in detail, because when this question comes up, they will always ask you the school of thought, and at some point you'll find yourself you have to tap it in and link it in with the relevances and its applicability in the society right now. So for starters, let's start with natural school of thought. Natural law, this was developed by people like Saint Thomas Aquinas. Then we have Aristotle also developed it, whereby Cicero and Saint Augustine, they started to champion the natural school of thought, but then Saint Thomas Aquinas and Aristotle, they developed it to broaden up the entire principle. And what are the natural school, under the natural school of thought, this is where we have the universal moral principles. That is where they defined the law as divine, it is just natural. Nothing comes with it. There are no conditions. No human developed it. Someone is just born with it. For example, most of the rights that we have, someone is born with the right. As long as you're born to live, you have the right to live. No one has to give you, no authority is entitled to come up and say, I'm the one to give life. I'm the one to give you the right to live. No. So under natural school of thought, it's universal moral principles, ethics, and reason that transcend the written law. It's developed in the 18th century. And when we are to talk about its applicability, let's indulge ourselves into the Constitution itself. Chapter 4, the entire chapter from the Constitution provides for the rights. And if you check out even the national objectives and directives, national objective principles and directives in the Constitution, they also indicate all that. And then also, if we are to look at Article 1 of the Constitution, it talks about sovereignty of the state.
Exactly.
With the natural law, it comes with sovereignty of as the state, they are entitled to protect these rights. It's their responsibility. Yes, we are going to have these rights, but it's their responsibility to preserve them, to make sure that we have these rights with us. So when you're tackling natural school of thought, you can talk about human rights. All cases that indulge themselves with human rights, you can use Kakweza Rukirabashaija versus the Attorney General. It's a very good case with human rights. And it even talks about the non-derogable and derogable rights. You guys all know that. Non-derogable rights are under Article 44 of the Constitution. The rest of the rights
are derogable.
Aside with the children's rights that come with other complications.
Okay, yes. So, Counsel, if we understand very well, does it mean that in the natural school of law, we only have these inborn laws?
Yes.
They are not written, but they're just natural.
They are just natural. They just come natural.
The divine law are based on beliefs and all that.
Yes, please.
All right. Thank you.
So they're just based on beliefs. Natural, inborn. No one first came up. It's not like the Constitution is the one that brought up the rights. No, the Constitution came up, but the rights were already existing. So that is it in short. Then after the natural school of thought, we are going to follow them in order, on their order of their development. We went to the positivism. And in the Positivism, it was developed by John Austin and maybe Jeremy Bentham. Yeah. Then there is Hans Kelsen. So all those people developed this, and it came up in around the 18th century, approaching the 19th century. Exactly. Yes, and in the legal positivism, according to them, they defined the law as the command of a sovereign, arguing that law and morality are separate. Like, yes, it's just a command. The sovereign is the one that commands it. It's unlike in natural, whereby it's inborn natural.
There is no sovereign authority.
No sovereign authority commanding it. The Positivism, it just came up to develop, and it's like, actually, it's them that give you the right.
Right.
Now let's give an example of it. Let's give an example of the right to life. You're born. As long as you're born, you have the right to live. But in actual sense, the state can take away that. Yes, whereas Uganda has developed, let's say, many arguments coming up about the death sentence, that it has been abolished, that never been abolished. They just brought in necessary other precautions that they should take before reaching the point of sentencing someone to death. Yes, otherwise the death sentence is still on. No wonder the penal code has never been like repealed or amended. It's still standing, which means that death sentence is on. It's natural. It's your natural right to live, but again, the state can take that away from you because it's commanding it. Then the law, it just comes with a sovereign state. We all know what a sovereign state is. A sovereign state commanding the law that yes, this is what you ought to do. You murder someone, they've established murder. There is motive. There is the mens rea, the actus reus. You have to be sentenced to death.
Exactly.
Yes, so that is it. Many people coming up with Susan Chigula, people are confusing it that it abolished the death sentence. Please, the death sentence has never been abolished. It still stands.
Exactly.
Then, if you are to follow up, let's go to the historical school of law. That is a historical school of thought. And in the historical school of thought, it proposes that a law is not found in legislation, but rather in the consciousness or the spirit of the people. Legal principles are discovered through historical experience and community custom rather than deliberate legislative. Now, these are just the customs that come up. Due to our customs, we develop a law. The law comes up. Exactly. Let me give you an example. Like Article 243 of the Constitution. If you actually check out the history of Uganda, just like in the preamble, in the history of Uganda, there is a lot of chaos that came up with between the government and the Kingdom of Uganda. Now, to reaching an extent of abolishing kingdoms. By 1966, the kingdom, the Uganda was in a mess. Kingdoms have been abolished. Now, Article 243 addresses this because of that historical background. Article 243 comes up to address the fact that kingdoms can be there. We can recognize them as long as they don't interfere with the constitution or anything political. So that's the historical version that comes in. It comes in to answer the other one that actually the state yes commands and all that, but still there is also history that backs up the laws that we make.
To mean that we rely on past events experiences to have the laws and legal text that will govern the actual community.
Yes, exactly. Yes, that's the historical version. Now, all these thoughts, you should put it in consideration that when you're discussing them, you define it, explain it, but then you have to give us its applicability in the society. The historical, you give us an example of maybe a statute, the constitution, you can give us a case law where it was applied. Yes, with case laws, we shall reach the scholars of thought. After the historical, we have the sociological school of thought, and this is this law. It should be studied like the social phenomenon that reflects societal needs and serves social functions. Now, the reality. This comes with the reality. You've done we've written. Yes, the law applies this way, but what's on ground? The reality. So this thing was tackling, this social school was tackling the reality, basically like how the reality shapes the law. Now let me give you an example. In Uganda, if you check about the case R versus MK, by the time that case came into place, they weren't recognizing customary marriage. No wonder, to them they considered customary marriage as the bride price. They considered it as a bride purchase. Yes, that's why you come in. That's where the case Mifome Uganda. That's when it comes in to address the fact that bride price ain't actually wife purchase. It's a custom and tradition, and it's not in any way not in line with the constitution. It's just in line with it.
A customary practice.
It's a customary practice.
And it does not violate the rights to dignity.
That is it. Yeah, it doesn't violate any rights. Therefore, it addresses that. Now, you see in 1917, R versus Amkeyo, they show us that customary marriage ain't recognized. But again, when we come in 1947, that is Ally versus Uganda, they tell you that customary marriage is actually considered as a type of marriage in Uganda. No wonder right now, when students are defining marriage, and they're using the case of Hyde versus Hyde, they don't just stop on that definition. Because in that case, they define marriage as union between one woman and one wife. Like, they just define it to the exclusion of any other types of marriage. So you find out that in this marriage, it's going to recognize only the civil and church marriage. But we have the Islamic marriage, we have the customary marriage that has a variety of other. Someone can have a variety of wives that they want. Yeah. Excuse me. So that's the sociological school of thought. So you tackle it, and then you also give us the authorities. Then after that school of thought, we have, and that school of thought, it was developed by Roscoe. Yeah, you can, he's another authority that developed it. Then we have the legal realism. That is Oliver Wendell Holmes Jr. and Jerome Frank. Now, in legal realism, they tell us that school of law, it came in as a result of judicial decisions and experience. These are precedents. Now we are indulging ourselves into precedents. And then that's when the Hunch theory developed. Now, with the Hunch theory, it was developed by Joseph Hutcherson, and he argued that judges decide cases based on personal intuitions. And then personal hunches, those are intuitions about the desired outcome, and then look at the legal precedents to justify their decision. Now, maybe a judge uses, when they're deciding a case, they preside over a case, they decide it using their intuitions, how they see what is right, what is wrong. And then they use other precedents. Now this brings in the using of precedents while deciding cases. Let me give an example of the marriage, the law related to matrimonial property. You shall find out that in some cases, for example, Hope Bahimbisomwe versus Julius Ravinumi, yes. In that case, matrimonial property was regarded as long as you've acquired that property within the marriage, the scope of the marriage, that property is regarded as matrimonial property. But even before that, what was the law going in matrimonial property? You would come with, you're married to someone. You come with your property, she comes with her property, and then when you go into a marriage, it's a legal union. So the property that you came within before the marriage would be regarded as matrimonial property. The law developed, precedents came in up. What happens? According to Article 26 of the Constitution, everyone is entitled to own property, whether in sole or in joint ownership. Now, what happens? Does that mean that the Constitution excludes the married people from owning property solely? No. So that's when the law comes in. Right now, if you check out, in the case of Peace, it was, I forgot the other name, but it's Pitts versus Kagwa. It's a marriage case that so famous about the curtains, the lady who was given only the curtains. Yes. Now, in that case, they tell you that you can come with your own property, which will only belong to you. The other person can come with their own property, which only belongs to them. Even in marriage, in the subsistence of the marriage, you can acquire your own property, and you can own it solely. It doesn't mean that when we are together, one of the partners will just sit, and then the other one acquires property, and then in the dissolving of the marriage, then we share that property. No, we can't divide that property. Someone can own it solely as long as the other person did contribute. As long as you put it in mind, court puts it in mind that there is monetary and non-monetary contributions. But if court finds out you didn't contribute either way, there is no way you're entitled to this property. There are 4. The first laws, they show you that according to that, the previous precedents, because the cases that come up, you have to reflect back on those precedents. And then they're like, yes, in this case they stated this and this, but is it the right thing? You give your own thinking, the ratio destined, and then they reflect back on the precedents. That's the legal realism.
Counsel, can you tell our viewers more about the principles of ratio decidendi and also the obiter dictum? Because I feel like this is where they really need it the most when they're explaining about realism, to talk about the precedents and how judges think before giving precedents and how they would depart, let's say, from a precedent. So just briefly, even though you won't broaden it so much because they have not yet reached the level, but just them to have a clue about what is ratio decidendi, what is obiter dictum, what is this and this.
Okay, ratio decidendi, in short, it can be like the reason for deciding.
Exactly.
Because let's give an example, really. If judges come up in a suit or in a case, and then they just come up and just say, okay, according to the facts, this is this. It just can't be there. They have to give you where they're coming from. It's giving flesh to the bone. Where are they coming from? The council has submitted this and this. Let me differ from it. Let it be like this and this. According to this, it is this and this. So it is giving you the reasons as to why. Before they give you their final say, they have to give you the reason as to why they are saying that. Where are they coming from? How did they analyze the entire thing? Other than just coming up and just saying this, it wouldn't make sense. Then the obiter dictum comes in also. It's kind of, there isn't mean the ratio decidendi, it doesn't, because ratio decidendi can be used as a precedent, as it can be used, you can use it as a reference in a precedent, other than the obiter dictum. Obiter dictum comes in like your own opinion, something that you can't reflect back and then you state it
just
somewhere.
A by the way.
It's like a by the way, yes. It is like a by the way.
Like Justice Okello just said, like, lands are not vegetables.
They are not vegetables,
that is
yes.
Just, no,
so you can't use that as an authority. They tell you define a land, then you define land resources, and then whatever, then after you say, land are not vegetables. Like, why are you telling us land are not?
So it is just a by the way that the judge
yes.
has said in his judgment.
Yes.
Just to maybe make meaning for something that he is trying to explain.
Yes.
All right.
Okay, and now the other school of thought, kind of like the last, it's the critical legal structure. And then this is the law that is the law as inherently political and often used to support existing power structure. Like for them, it's kind of like based on the Karl Marx theory. The economists know that. Like it's the rich that benefit. Like the rich control the poor. So the law is just always made to favor the rich, the powerful, the people who have the power. So these people who are powerless, they just have nothing. That is the critical thing. And then with the critical legal studies, it came up with the feminism coming up, supporting women's rights. If you find out most feminists, they just attack. Most of them, they are always critical. Most of their articles and journals, critical, like, why are men like this? Why is it that for us women are like this? That is it. So it just came up to criticize the entire thing. It's like punching in gaps into all these theories of law. Yes, that is it with it. Then maybe you can give an example of one of the other critics. You can give in any examples that have come up to criticize the law in some way or the other. For example, FIDA Uganda, that is the Uganda Women Lawyers Association versus the Attorney General, the 2004 case. Like, it was criticizing the fact that the law is there, it has been developed. But why is it that a woman has to go an extra mile to prove her ground of adultery to divorce or to prove any ground for divorce? Yet men, it could just come up. It's like that. Right now we have a lot of criticism coming. Now this is like the modern. I feel like it's even still developing because up to now we are still criticizing some things. For example, you can find men who are assaulted. they're above 18. Well, the law recognizes that only sexually assaulted men, they're supposed to be below 18 years. What happens to someone who is assaulted and they're above 18? Why is it that it's only women who can be assaulted at that point? So it's still neglecting in other people. There are still more gaps to fill in. So all that's the critical legal studies. And then maybe to add on all this, generally, you should never forget that schools often overlap and influence each other rather than like strictly replacing one another. We can't say that natural school of thought was replaced by the positivism. No, it is just relapsing and influencing the other. Because of the other one, this one reacts. So theories develop.
Due to development of the society.
That is it, exactly.
All right.
Yes.
We are so grateful to have you again at Agora Legis Phelistah. I hope you guys have enjoyed it. We have looked at the schools of thought, and thank you for watching. We urge you to like, subscribe, and share, and see you in the next video.